Let me come back to court-ordered interim measures, now under the 2006 regime. Article 17J provides a court shall have the same power of issuing an interim measure for arbitration proceedings seated in and outside its territory as it has in relation to court proceedings. It also states the court shall exercise such power in accordance with its own procedures in consideration of the specific features of international arbitration. I have mentioned the test and outcome of an application of interim relief may be different depending on whether it is heard by an arbitrator or the court. Courts will apply their own procedure to applications for interim relief. This is recognized in Article 17J, which, as I have mentioned, provides that a court shall exercise such power in accordance with its own procedures, although it does also add in consideration of the specific features of international arbitration. I have already made the point that arbitral tribunals should not be bound by court procedure and should have the latitude to apply other, less parochial and more transnational standards to the determination of interim relief. Courts may also have considerations that a tribunal may not. An example of this would be the decision of the Singapore Court of Appeal in a dispute between the Maldives Airport Company, owned by the Maldives government, and GMR, an Indian company that held a concession to operate the airport at Male. The dispute was subject to arbitration under the UNCITRAL Rules. The arbitration was seated in Singapore. GMR, the claimant in the arbitration, applied to the Singapore Court for interim relief in aid of arbitration. The High Court granted the relief. It was an injunction. The Court of Appeal set it aside. The court applied the well-known balance of convenience test laid down in the English common law and the American Cyanamic case in deciding whether the injunction should be granted. The court decided the injunction should not have been granted. The court found that balance of convenience was not in GMR's favor. The court found that GMR could be adequately compensated in damages. The court also found that practical problems argued against the grant of the injunction. These were the breadth of the injunction, the impact of the injunction on the actions of the Maldivian government authorities, and that the injunction will require an unacceptable degree of supervision in a foreign land. Two aspects of the decision stand out to me. First, the application of the balance of convenience test, and, as part of the balance of convenience test, the consideration whether the injunction will require an unacceptable degree of supervision in a foreign land. While the court was bound to follow the balance of convenience test by its precedents, in my view, a tribunal need not have applied that test. That is a test used in the courts. Arbitrators have a latitude to decide what test to apply. A tribunal may decide to adopt a more transnational and less parochial approach. I also query if the degree of supervision in a foreign land would have weighed on a tribunal to the same degree that it did in the court. International tribunals, while seated in a particular jurisdiction, by their nature deal with cross-border issues, and in my view, need not be constrained by the more parochial viewpoint that a court must take. Further, a tribunal's approach to the enforcement of its orders or awards is necessarily different from that of a court. A tribunal cannot enforce its own awards. Enforcement remains the province of courts in the jurisdiction in which enforcement is to take place. If the decision on interim relief was issued as an award and was recognized as one, then enforcement would be available under the New York Convention. Further, the 2006 amendments to the model law and certain national legislation provide for the enforcement of interim relief ordered by a tribunal, even if not in the form of an award. A tribunal will be justified to take a different view on cross-border enforcement on this basis. I use this case to illustrate the point that there can be substantive differences in the approach a court and a tribunal may take on interim measures in arbitrations. Where parties to an arbitration have an option other than the court when interim relief is required, they do need to consider carefully and strategically in each case whether they will be better off applying to the court or to a tribunal. The tests used, standards applied, and outcome may be different depending on the forum. I have one final point to make. Article 17J of the 2006 amendments provides that a court shall exercise such power in accordance with its own procedures in consideration of the specific features of international arbitration. In my view, Article 17J calls for a measure of convergence of the test that a court may apply compared with what a tribunal may apply. This is a good thing. Just as international arbitrators should seek to devise transnational standards to suit the transnational nature of the disputes before them, courts, when hearing applications in support of international arbitration, should adopt tests that take into consideration the specific features of international arbitration, even if this requires deviation from the accepted tests that may apply to litigation of disputes in those courts. Thank you for listening.